Good day to you and welcome to another Paddocks Club video tutorial. Today I want to talk quickly about the Protection of Personal Information Act, which has now been signed by the State President and is Act number 4 of 2013. It is referred to as POPI. It was published on the 26th of November 2013. You can find it in Government Gazette number 37067, which you can download from the government site. It is intended to protect the personal information processed by both public and private bodies, to establish an information regulator, to provide codes of conduct, and fundamentally it gives people rights in respect of unsolicited electronic communications and automated decision-making, which is based on data. So why should sectional title bodies, corporate homeowners associations and managing agents care about this act? Well, because they process people's personal information all the time, and that of course begs the question, what is personal information? It has a very wide definition in the Act. In essence, it's any information relating to a person. It might be their race, gender, whether they're pregnant, their marital status, almost anything. It includes significantly their education, medical, financial, criminal or employment history, also any ID number, email or any other address, a telephone number, their location, private correspondence, and the views or opinions of others about a person. So everything you have on file about an owner, an occupier, tenant, or otherwise a supplier is personal information. And each person is referred to in the Act as a data subject. The body corporate or managing agent is, however, a responsible party because it processes personal information. All that means is that you keep and manage this information. In the processing of personal information, you need to avoid intruding on a data subject's privacy to an unreasonable extent. All information must be collected for a specific, defined and legitimate purpose, and you can't further process that information for a different purpose. So for example, if somebody comes and says, can you give me a list of all your owners because I'd like to send them some other information, or if you're trying to sell some other goods or services, that's not why you collected it, you can't use it for that purpose. You must maintain the information quality, that is, that must ensure that it's accurate and complete, not misleading in any way. You must have appropriate technical and organizational security safeguards for the information. This touches upon your IT and operational arrangements. The information must be open to the data subject, who is entitled to know what information, the actual details of that information, and why it is being kept. What must you do? Nothing at this stage, because the Act isn't yet in operation. When it does come into operation, you'll have a year to comply with its requirements. But at the moment, I suggest you start thinking about what data you keep, how it's stored, secured, how you use it, and how you now and in the future will make it available to others. Thank you for joining me in this video tutorial. If you have any questions about this Act, we can chat about them in the discussion forum.